Thank all of you who are trickling in. We're just going to give it another minute or two before we get started.
Hi, Andrea. Would you kindly move us to slide 2, please? So welcome everyone to our webinar on guardianship practice and less restrictive alternatives. We are incredibly pleased to have such a diverse and engaged audience today, including court staff, guardianship stakeholders, judicial officers and their staff, as well as social workers, attorneys, and other dedicated professionals. Today's discussion addresses a critical and often complex area, navigating the delicate balance between protecting vulnerable adults and respecting their autonomy within guardianship proceedings. As many of you know, determining whether a person's safety necessitates overriding their independence can be a profoundly challenging judgment. While some cases present clear paths forward, many demand a more nuanced and sophisticated approach. Our aim today is to delve into this complexity, explore strategies for providing a consistent, theory-informed framework for guardianship evaluation, identify existing gaps in evidence, clarify individual strengths and limitations, assess the potential for abuse within guardianship, consider less restrictive alternatives, and identify opportunities for limiting the scope of guardianship when necessary. To guide us through this important conversation, we have an exceptional panel of experts from the University of Southern California. It is my distinct pleasure to introduce them to you now. First, we have Dr. Bonnie Olson, a clinical professor and researcher at USC. Dr. Olson's work is deeply focused on understanding the intricate ways in which elder abuse occurs, particularly within the context of people living with dementia and the critical intersection of guardianship and elder abuse. Next, we welcome Lori Mars, an assistant professor and researcher also at USC. Assistant Professor Mars brings her legal expertise to the forefront of elder abuse prevention, examining the crucial interplay between the law, aging, education, and the prevention of elder abuse. We are also honored to have Kelly Marnfelt, a doctoral candidate and researcher at USC. Kelly's research delves into the vital intersection of autonomy and vulnerability in aging, with a significant focus on elder abuse prevention and upholding the human rights of people living with dementia. Not joining us today, but a significant contributor to the evaluation of the work presented is Alexis Cogan, an assistant professor and researcher at USC. Dr. Cogan's work centers on developing and implementing person-centered models of care and education for older adults and individuals navigating serious illness. And finally, we have Ro Peterson, a project professional and project administrator at USC. Ro's extensive project portfolio is dedicated to initiatives aimed at both understanding and effectively preventing elder mistreatment. Please join me in warmly welcoming our distinguished panelists. We are eager to learn from their expertise and insights on this vital topic. So let's get started.
Thank you so much, Aisha, for that great introduction. We really are very happy to be here today and welcome everyone who's participating in the webinar. First, I wanted to say we had generous support for this work from both the Department of Justice through the Elder Justice Initiative, as well as the Administration for Community Living. And we have no conflicts of interest to share regarding the work. So just to reiterate what Aisha just shared, next slide, please. We can see that there is this tension, this tension that relates to the desire that guardianship be the least restrictive mechanism, and at the same time also provide significant safety and protection for the individual. We recognize that there's a national effort for it right now with the intention to more intentionally support autonomy and guardianship, and whenever that's possible. And there are many times in cases where it isn't, but when it is possible, that we move and sort of lean into that a little bit more. Of course, we know that as we sort of lean into that autonomy more, it does create the opportunity for more risk in the situation. So it's that tension that we live within right now, and why we really are addressing this work and hoping that it brings things forward in a more intentional way. When we lean into the safety side, it lets us sleep better at night. We know that people are tucked in and they're very safe. But the cost of that is really borne by the clients, who then lose a great deal of autonomy and then end up often spending the balance of their lives under court supervision. So that's where the tension lies, and why we're here to try and develop tools and strategies that will help the court to really do that well. So moving along, next slide. You'll see that this is what we're going to be talking about, is two phases to this project. We'll walk you through what we learned from both of them, both phrases, and then also talk about some tools that we've developed and putting this worksheet into practice in the courtroom. Next slide. So the next thing we'll be talking about is the development of the worksheet. And this is the primary tool that we've developed for use in the court. So it's based on a theory, a model that we've developed related to elder abuse. And so why is elder abuse and guardianship connected? In what way? Why are we even bringing that concept into this process? Well, first off, when an older adult has been victimized, guardianship is often a common remedy to that problem. So the guardianship often serves as a protection for ongoing harms that might occur if we were to leave it alone and not intervene. Secondly, elder abuse, despite our efforts to avoid it from occurring, can occur within the guardianship. Guardians are in a position to use their power to exploit the person or neglect or mistreat the very person that they've been charged with protecting. So it's that risk that comes through the guardianship, as well as the risk of abuse that occurs leading up to it at times. Raising awareness about these risks improves the court's ability to avoid those kinds of outcomes, and that's intentionally what we hope to accomplish. So the AIM model itself was, sorry, there you go, thank you, was based on evidence that was generated from published studies, as well as over 1,000 cases that were seen in the Elder Abuse Forensic Center in Orange County, California. Going back, oh gosh, at least a decade, if more. And so putting all that information together regarding elder abuse, we found that the risks for that occurring fall in three general domains: the vulnerable older adult, the trusted other, and then the context that the two of them interact within. So it's not meant to predict, sort of which risk is at play in any one case. It's not prescriptive in what you ought to do to remedy those risks, but it does help to organize all the information and the factors that might be active in any particular case or situation. And it may help you to determine how to intervene once you identify when there are modifiable risks. So that was sort of the premise. We published this paper. Back in 2016, a probate judge in California read this paper and then applied it to cases in her caseload regarding guardianship. And she felt that this model would be a useful tool to help judges to do a better job of recognizing how elder abuse and guardianship, there may be an interplay there. So it stimulated the work to apply the model to probate guardianship issues, and it led to the first phase of the project, which was completed back in 2022. So that's sort of how we got here. What is this tool intended to do? It's intended directly to be a mechanism to support judicial decision-making. So just from the outset, this is for judicial decision-making. It provides a consistent theory-informed framework for guardianship evaluation. It identifies gaps in evidence, and it helps the court to clarify the respondents' strengths as well as their limitations. And then it provides access, it allows the court to assess the potential for abuse that might occur through the guardianship, and then to consider less restrictive alternatives to guardianship, and possibly to identify opportunities for limiting the scope of the guardianship. So those are what we were hoping this tool would do for the court. Next slide. I want to make sure that it's clear to everyone here participating that it was developed really with the background based on older adults. And so it's not really related to adults with mental health conditions or adults with disabilities. Now, many of the factors that are embedded in the worksheet apply. All I'm saying, though, is that it's not based on the research that we would know about those other populations. So use it in that regard, understanding that it was really based on the research for older adults. It's also intended to inform judicial review of guardianship cases, but it's also useful for, and you'll learn more about this as we go along, for other professionals that are associated with the court. Individuals such as guardians ad litem, court-appointed attorneys, examiners, investigators, visitors, and law clerks, all the professionals who support the judges in the whole probate process. So we'll provide more more information about how and why those other individuals were brought into this whole process. Okay, Ro, would you please put in the chat the worksheet and the glossary so that's available to participants? And then I'm going to hand it off to Lori here and allow her to then describe the content of the worksheet. Thank you.
Thank you, Bonnie. Next slide, please. So let's begin with the process we undertook to develop the worksheet. And with the support of the Department of Justice Elder Justice Initiative, our USC research team led by Dr. Olson developed and designed the Judicial Guardianship Worksheet. We convened an expert advisory board comprised of judges, attorneys, and academics engaged in guardianship practice and research, and we solicited their input on the general structure, language, and format of the tool. We then recruited 3 focus groups of judges from probate, general jurisdiction, and tribal courts nationwide. They reviewed draft worksheets and provided guidance and suggestions, which we integrated into iterations of the tool. And then we pilot tested the final tool with 51 judges from 22 states. Each judge was asked to undergo a 30-minute training session. They took a pre-test survey, And they were asked to use the worksheet with at least 5 older adult guardianship cases. And one judge used it in over 90 cases over the study period. But at the conclusion of the study, the judges responded to a post-test survey and a final exit interview about their use and perceptions of the worksheet. Importantly, we were not prescriptive about the use of the worksheet. Some judges printed out and filled out the form for each case. Others filled it out in PDF format, and others just referred to the form as a bench card as they reviewed cases. And you're going to hear more about the pilot study in just a few minutes from Dr. Olson, but as a preview, the worksheet was very well received and reviewed by the study courts. Next slide, please. So let's turn now to the adaptation of the abuse intervention prevention model to the new tool for use in guardianship courts. And you can see the original model on the left and the application on the right. So some of the terms have been changed. The vulnerable older adult has now been changed to respondent in the new framework. Trusted other is the proposed guardian. We still have a spot for context, but you can see that there are different spokes in the wheel. And in the new format, in the new framework, those spokes correspond to the factors considered by courts in guardianship case review. And at the very center of the tool, we added less restrictive alternatives and retained capabilities, which remain a focal point through this review. And you'll see it as I share with you the worksheet itself. Next slide, please. Thank you. So we took that model and we translated it into a 2-page worksheet. The first page largely relates to the respondent and factors within the respondent's world and their ecosystem that relate to guardianship and would be relevant to the court's consideration of the petition. And on the next page, which we'll see in a moment, there's information related to the proposed guardian, the context of the relationship of the respondent and proposed guardian, and then less restrictive alternatives. This form is available in printed format. It's available as a PDF. It can also be used as a bench card in a number of ways. And as we're looking now at this first page, you can see at the very top, there's some space where you can record case-based information. The case number, the name of the respondent, the petitioner, the proposed guardian. You can indicate what kind of guardianship is sought, whether it's guardianship of the person, the estate, both, or something else. You can record the hearing date, the precipitating event, if any, and then whether the petition is contested and by whom. And then in the upper right corner, there are links to a worksheet orientation to provide information about how to use this worksheet. And then just below that, there is a link to state probate statutes. So as we turn now to the respondent section, you can see that there are different domains here from A to I. And the first one addresses respondent's background, and that includes information about the respondent's age, education, marital or partnership status, occupational history. And here you don't need to record every job that the individual has held, but perhaps their primary occupation or most recent occupation. Their level of literacy, their preferred language, whether an interpreter is required. And this provides a foundation for the information that will be gathered in subsequent sections and gives you an idea about the individual before you in court. In the next section, cognition. There are checkboxes to note areas of concern relating to memory, concentration, wandering, aggression, and delirium. These are some aspects related to cognition. It's not an exhaustive list, but some common issues that can arise within this domain. There's also an area to record a medical diagnosis of dementia, if there is one, and to indicate the degree of severity, if there is a diagnosis, mild, moderate, or severe. There's also a place to record any medications that have been prescribed. And if there's no known deficit, you can tick that box as well. And very importantly, in this section and a number of the succeeding sections, there is a line to note retained abilities. Because in addition to limitations, we do want to understand the abilities the preserved abilities of the respondent to enable the court to consider the individual in front of them, perhaps identify unmet needs that can be met through less restrictive alternatives, or if guardianship is deemed necessary, perhaps limited orders would be more appropriate. In section C, this next line item addresses mental health to better understand any presenting areas of concern in this domain, and if they potentially impact their decision-making ability. There are checkboxes for depression, anxiety, hallucinations, delusions, impulsive behavior, substance abuse, and hoarding. Again, this is not an exhaustive list, but provides the most commonly observed mental health conditions in the older population. There's also a line to add any other mental health conditions that may be relevant, any diagnosis and medications prescribed, and if there's no known deficit presented, there's a place to tick that box. There's a final row also dedicated to comments if you have any regarding this section. Turning to D, this domain focuses on medical conditions and physical functioning. Again, the areas referenced here are commonly observed, but not a comprehensive list. And you may list relevant diagnoses and tick boxes for inadequate self-management, mobility concerns, falls, pain, frailty, and incontinence if applicable. There are also places to note any sensory concerns, including visual concerns or hearing impairment or the use of adaptive equipment. And if no known conditions are present, there's a place to denote that as well. You can also see within this section, there's a place to record if these conditions are acute, chronic, or reversible, because we do want to understand if these are short-term ailments or whether they're long-term. This, of course, will inform a court's decision on the appropriate remedy. Section E and Section F relate to respondents' activities of daily living. E relates to basic activities of daily living, because we want to get a sense or a better sense of respondents' level of function. So in E, different activities include bathing, dressing, toileting, and grooming. Also, there's a place to indicate any retained abilities. Of course, very importantly, we want to understand what they can do. And there's a box to indicate no known deficit if none is present or observed. And then dependence on others for activities of daily living often signals a high level of daily caregiving, which is important, of course, in determining the appropriate remedy. Instrumental activities of daily living in Section F relate to those more complex multi-step activities relating to respondents' ability, for example, to do their own meal prep, housekeeping, manage finances, go shopping, take medications, coordinate transportation, or use the internet or phone. Again, there are also places to indicate other activities, whether there's no known deficit, and any retained abilities. And we want to understand respondents' preserved abilities, as this is important to, again, identifying less restrictive alternatives, or if necessary, developing narrow and tailored orders. Turning to Section G, judgment, reasoning, and executive functioning. Evaluating judgment and reasoning is necessary to determine respondents' ability to make practical decisions and solve problems in real-life situations. The areas of concern referenced here are respondents' ability to identify abuse, neglect, and protect oneself from harm, recognize ambient danger and respond to emergencies, their understanding of their care needs, susceptibility to exploitation and undue influence, and whether there are any prior episodes of mistreatment or other concerns. Again, this is something we want to understand. Has this respondent experienced mistreatment before? By whom? Is it from the proposed guardian or someone else? And what are the circumstances that may be relevant to the court's determination? And there's also a place to note no known deficit. Under Section 8, social connectedness, we do want to better understand the respondent's level of social connectedness and social support, who the respondent's relationships are with, what is the quality of those relationships, and how do these factors impact their well-being and care needs. And are there any recent events that perhaps may impact respondents' susceptibility to harm or abuse? That could include a recently relocation, a loss of a significant relationship through death or divorce. And the lack of a significant long-term relationship or attachment is also informative for the court. And then finally, and very importantly, values and preferences, understanding what is important to respondent. What do they want? What are their goals? What are the outcomes and resolutions that they would like to achieve? Do they want a guardian? Do they want this individual to serve as their guardian? And what are their most valued relationships and with whom? And is their current decision-making consistent with prior practices or preferences? Or is there a change? And if so, what is the reason for that change? Do they have a religious or spiritual affiliation? And is that important to the determination of guardianship? Do they prefer family care or formal supports, something they would be interested in, or do they want to age in place? Lots of considerations to focus on. Do they have a pet, and is it important for them to maintain their contact with their pet? And do they reject needed care? So all important considerations to address. So let's now turn to the next slide, please, to focus on the proposed guardian and those areas that we should address. And this section provides guidance to evaluate the propriety of the individual or institution seeking guardianship. In the first line, you can see we're interested in what type of guardian this is. Is this a lay or family guardian, a private professional, a public guardian, a financial institution? Do these private or public institutions, do they have certification? Certification may be required in some jurisdictions, not others, but it is available through the National Guardianship Association, and perhaps can provide an added layer of training and education for guardians and an added layer of assurance to courts. Next, in section A, background. Importantly, age, highest education, employment history are relevant and important to understand the background of the individual seeking guardianship and understanding their ability to provide care or financial management of the older adult. In section B, dependency. For a lay or family guardian, we want to better understand their relationship with respondent. Financial or emotional dependence by trusted others on older adults are risk factors associated with mistreatment, financial abuse, emotional abuse, neglect, and other harms. And we want to understand who the proposed guardian is, the nature of their relationship with respondent, any pressure points or triggers that could lead to abuse. And we do know that financial or emotional dependence could serve as a catalyst to abuse. In section C, functional limitations, again, for a lay or family guardian, we want to understand any limitations that they may have that may impact or impede their ability to serve as guardian, whether that's cognitive, mental health, physical concerns, or other. And this information may or may not be accessible or available to the court and may or may not surface in an examiner's report or investigation, but it is relevant to the proposed guardian's ability to provide care for the respondent. For example, often an older adult may seek guardianship of a spouse, and they themselves may have medical, mental health, or cognitive or functional impairments that could affect their ability to care for their spouse and serve as guardian. There's also a place in this section to indicate if there are no known deficits or this information is unavailable. For guardian history, this enables the court to identify any areas of concern for lay, family, professional, and private guardians. Some of the factors relate to lay guardians, others to private, professional, or public guardians. And we want to understand, especially for private guardians, public guardians, the number of cases they're currently managing, the number of cases they've managed in the past, to gain an understanding of the guardian's commitments and responsibilities. Do they have experience to serve as guardian? And at the other end of the spectrum, are they overextended such that financial mismanagement or neglect may occur? Other elements to consider in boxes to potentially tick: has the guardian ever been removed? Has their license been revoked? Has a surcharge been imposed? Are they rep payee? Are they bonded and insured? Do they have a poor credit history? Do they have a criminal history, especially for family or lay guardians? Any past or present criminal history, any prior or current APS complaints and protective orders, and whether they filed bankruptcy. And for private, professional, and public guardians, this information is relevant to assess the potential for financial abuse, and also whether the proposed guardian might potentially ignore their fiduciary duties, and subvert the preferences and values of respondent. For example, might a guardian use the ward's funds for their own purposes and financial gain rather than support respondent? They may misappropriate funds or spend down assets or place the older person in a nursing home, though it has always been their preference to live at home and age in place. So it's important to understand these factors as part of due diligence and to the extent possible, uphold the older adults to preserve the older adults' dignity and respect and uphold their own fiduciary obligations, that is the proposed guardian's fiduciary obligations, to best meet the needs of the respondent. So let's turn now to context to look at the larger landscape of the relationship in which the respondent and proposed guardian operate. So here we want to get a sense of, in section A, you can see respondents' resources. What are their sources of income? Do they have a pension? Do they receive Social Security or an annuity? What is their monthly total income and the value of their estate? Are they a veteran? Do they have access to veterans' benefits? What type of health insurance do they have? Medicare, Medicaid, or something else, or nothing else? Are there any barriers to access to services and assessments? And do they have internet access? Then we turn to section B, living arrangements. Are they adequate and appropriate? With whom do they live? Do they live with the proposed guardian? Is there a concern there? Is that something that needs to be addressed and delved into? And there's a line for comments, for you to record comments about this issue. And then section C, relevant relationships. What is the family structure of the respondent? What does that look like? Who is in their world? Their family members, are they married? Do they have a significant other? Do they have children, other family members or neighbors who are involved? And what are those family dynamics? What does that look like with each of those individuals within that ecosystem? Any other supportive relationships that may be relevant can be indicated on this form. Any other involved parties that can be reflected here as well. And importantly, any areas of conflict with any of these individuals, important for the court to understand and consider. Are there, and to that point, are there any pending legal actions or protective orders or prior legal actions or protective orders involving the proposed guardian? In section D, what is the respondent's relationship with the proposed guardian? We want to understand the nature and history of that relationship. Is this perhaps an adult child and an older parent? Maybe they had a wonderful relationship over time. Perhaps they've had a conflicted relationship over time. And we want to gain a better understanding of what that looks like. Are there actual or potential conflicts of interest that could potentially portend abuse? Is the respondent dependent upon the proposed guardian? Yes or no? And section E relates to current legal instruments. Are there instruments in place, a will or trust? Who is the named executor or trustee? And when was the date executed? Was it executed many years ago? Was it executed more recently? Are there some concerns with that? Do they have a power of attorney, a medical power of attorney or financial power of attorney? And what were the dates that those instruments were executed? Next slide, please. So now we're going to focus on the less restrictive alternatives, because of course we want to gain a better understanding of respondents' unmet needs and how we can best meet those unmet needs while hoping to enable them to retain agency and autonomy to the extent possible, understanding their preserved abilities while also being mindful of the limitations they may have. So looking at less restrictive alternatives, there may be alternatives, again, to meet those unmet needs. And a little bit later, you'll hear from Dr. Olson about a sheet that we developed regarding less restrictive alternatives to provide some guidance in that respect. But some types of less restrictive alternatives that can be attempted, or perhaps have been attempted in the past, or new ones that can be suggested, include hired or family caregiver, home and community-based services, memory aids, assistive technology, whether there's a medical power of attorney, a hired or family caregiver, direct deposit, opportunities for a joint account, rep payee, financial power of attorney, a trust, whether there's a supported decision-making agreement can be very effective, or some other form of alternative. And then, of course, we want to focus on retained capacities. What are they? And this is a place to indicate that on the form, to place value on those issues that are so important to determining any orders that may be issued. Also, see if an order is necessitated. Perhaps there are areas to create narrow or tailored orders. And then D provides a space to put summary notes. Anything that maybe you have thought of after review of all of the information on this worksheet that may be relevant to the court's determination. So next, I'd like to turn back to Dr. Olson to talk about the pilot study findings.
Okay, thank you so much, Lori. Appreciate all that information about the content of the worksheet. There was a couple of questions that came in on the Q&A here that I think is probably relevant to address first. There was a couple of questions about who fills this out, and then where was it, how was it developed? Well, the people involved with developing this were primarily the judicial officers, so through focus groups and on our advisory board. So it was really the people in the court system, the probate court system, who were involved with informing us about what the content that was relevant, that should be brought forward to the judge in throughout the process that I would call from petition through appointment. So during that pre-appointment period. The content is not intended to be exhaustive. So there was some questions about why was this not included, or why was one factor and not another. We just tried to include the most frequent types of issues that arise, but there's clearly others that could be included, and that's why there's room to include, for comments or additional information in any of the areas. Who fills this form out? Well, we'll get to that in a little bit, because it was intended for the judges, but it is not meant that, or we don't need to imply that all this information would be gathered by the judges. The petition and then all the reports that flow into the court during that period from petition till the hearing is held, all that information is aggregated in this worksheet. Now, we weren't sure if it would be the judges who would be filling it out, or would it be people who support the judges, or how would it get used? So that's what I'm going to talk about right now in what was the findings from that pilot study. We developed the tool for the judges and then gave it to them. And in the pilot study, that the findings from that tell us how those judges found it useful or not. So next slide. Okay, so first off, the judges definitely said that it was comprehensive. It provided an organized register of the relevant factors that they would be considering when they're adjudicating a probate matter. It helped them to highlight the gaps in the evidence, and then that could prompt them for asking questions in the hearing. So that was clear. Pretty universally, they all said, yes, that was helpful. They found it most helpful in cases that are more complex, like maybe cases that came back multiple times, or there was a lot of issues at hand, or those cases that were contested. Either there was competing petitions, or just they were contested petitions. And particularly when they were cases that would require ongoing case review. I'm not talking about post-appointment, but that there was multiple hearings before it was resolved and a determination was made. The court found that the tool helped them to track that information over multiple hearings. They also said that it reinforced their objectivity and caused them to reassess any biases they may have held pertaining to clients, the respondents. And so they appreciated that it was a consistent approach, that they were always looking at the same information, despite what the case was. And then in response to that, it increased their confidence in their decision making. So they found that it was valuable in that regard. Not just their own consistency in using a consistent framework, but they felt like, ooh, this, you've seen one court, that it could provide some consistency across jurisdictions. And right now we know there's a great deal of variability from one court to another. And in one way or another, many of the judges in the pilot study voiced a embracing of a conceptualization of a more holistic, person-centered review, meaning that, oh, this feels like more like a whole person than just what they can't do once they had this information in an organized way. So those were sort of the more systemic improvements that they felt could occur as a result of the worksheet. Next slide. Okay, so how did it get used? First, most of the time the judges used it as a guide. They kept it benchside during hearings. They kept it beside them when they were reviewing the file. They didn't necessarily fill out the form and tick all the boxes. Sometimes, yes, sometimes they actually did that, but more often it was used more like a bench guide. And they really felt that it informed the universe of relevant information, that if there was something missing, they would see it, and then it would cue them to ask more questions. They all individualized it to their own process, how they approached their review the file, and then what they did in the hearing and how they wrote their orders. It tended to simplify the complexity of these fairly complex cases. And it did help them to identify the potential for elder abuse. Now, moving to the queuing for less restrictive alternatives to guardianship, they did feel that it was helpful because they would see better how the individual was able to function in some areas and not function well in other areas. So it allowed them to do that kind of discernment about like when would a less restrictive alternative be potentially operating, and possibly to cue them to consider limiting the scope of the orders or writing more targeted specific orders. But it's not clear how often that actually happened. We didn't have any measure of that. So that's what we learned from the pilot study. So that was, and most of that really comes from the qualitative interviews as opposed to more quantitative information. Next slide. Okay, now I'm going to move on to the second phase of this project, which we've been engaged with for the past year, essentially. And so next slide describes like sort of how we got here. So this work was stimulated by both ACL and the Department of Justice in wishing that we would take this tool and then see what it could do when it was implemented in a court system. So they approached the 10 states who have ACL-funded guardianship innovation grants. And most of those, I believe most of them concluded. They may be in a no-cost extension, but I think the bulk of the work has been concluded. But there was 10 states overall who had engaged in this process. They were approached, and from those 10, 2 jurisdictions self-selected to be engaged in this project, the implementation project. And they were solicited because they seemed to have a high likelihood of engagement with the worksheet and strategies that would allow it to be useful to the court. So next slide. Okay, so the first thing we did in this effort of implementation was to really gather information about how does each of these 2 jurisdictions work. So we're referring to these as jurisdiction A and jurisdiction B. So one is a probate court division and the other is a general court. So very different. In the probate division court, all those judges were assigned to probate, and that's all they did during their period that they were assigned to it. As opposed to in the general court, that judge was seeing all kinds of cases, maybe some civil, some criminal, some family law, and some probate. So it was all mixed together. So that changes sort of that structure in a pretty important way. The next really pertains to the information that comes from the statutes, that it was statutorily required in jurisdiction A that a court-appointed attorney was always appointed, and as a result, only rarely was there a need for a guardian ad litem. In jurisdiction B, it was statutorily required that a GAL, a guardian ad litem, be appointed in each case, and only rarely was a court-appointed attorney. So that dynamic, we believe, probably had a big influence on how guardianship was considered in those jurisdictions. Examiners, like doing the more capacity assessments, those kinds of examiners, was done in jurisdiction A by a impaneled group of social workers who often, not on the same case, but on different cases, also did court investigative role. So the same social workers might do it in one case, be an examiner, in another case, be a court investigator. In jurisdiction B, there was no panel of examiners. They were either private physicians or it was an assessment obtained privately, or it was obtained by the medical facilities when a respondent was in a long-term care facility, for instance. They very rarely, you had need for a court investigator. That role was filled by the guardian ad litem, who did that investigation and then prepared a report for the court. So that's all the information that flows into the court through after the petition is submitted. But then someone typically summarizes and reviews that file in preparation for the hearing and to help the judge. That role is filled in jurisdiction A by their court clerks, which are law students who then are assigned to that judge. And so they're trained to do that and how, and that judge gives them direction on that. In jurisdiction B, that process is fulfilled by the guardian ad litem, and the judge and the guardian work closely together so that the guardian understands what the judge is looking for in that summarization of the file. So those are just the two structural differences that we learned about as we delved into the details in those two jurisdictions. Next slide. Okay, so then we developed sort of a pragmatic intervention strategy here. Like, well, so now, well, how are we going to help these courts to implement this worksheet in a really pragmatic way? So we were treating them, because they're so different, as really case studies. And just because the structures and the cultures and the practices in these two jurisdictions are so different. And they have different roles and responsibilities for who does what when. So what we determined was that focusing on training the support professionals, all those people that assist the court in processing these petitions, would be really useful, since those are the individuals that are bringing the information forward to the court. And that includes guardian ad litems, court-appointed attorneys, examiners, visitors, and investigators. And we also wanted to train the court clerks, but wasn't able to implement that. So the focus was really on training all of those professionals on the content of the worksheet, and then helping them to develop strategies for more intentional consideration of less restrictive alternatives. Once the judges were engaged with the process and the tool, the worksheet, they reported that it really did improve their practice. We did hear through that training that the support professionals also were voicing sort of a difficulties and struggles with coming up with what might less restrictive alternatives be. What are those LRAs? And needed some help with operationalizing that. So we'll turn back to that in a little bit, but that's what we were hearing from them as we were doing those training sessions. So next slide. Okay, one of the things that we were asked to do was to understand better how the aging services network intersects with the court. So first, let me just say, what are aging services network? That term is really referring to, in our use, all the agencies that might be engaged with providing any kind of social service or support to community-based individuals who might end up the subject of a petition for a guardianship. So legal aid, adult protective services, ombudsman, certainly area agency on aging, and all those agencies that get referrals through them. And then home and community-based services. So any of those, so it's really a broad sort of net. And so the interest was in understanding, how did those services intersect with the court? Since most of those services would be the access point to less restrictive alternatives. And so what we learned was, in the pre-petition or pre-appointment phase of guardianship, there's not a lot of intersect, that there isn't a direct link to the court. And it's only likely or systematized, I should say, in the post-appointment oversight process. And then, in some jurisdictions, not in others. But really in the pre-appointment, there was no structured way that these aging services networks are really engaged with the court. So next slide. Okay, so now I'm going to talk about what did we learn from this year of implementation and application of the worksheet in these two jurisdictions. Next slide. Okay, so I'm just going to start off with a little bit of theory. So this is the theoretical underpinning of what we measured and what we're hoping to gain from it. So the idea is here that behavior change is based on beliefs, attitudes, and knowledge, and those together end up creating subjective norms that are followed. If you're going to change any of those beliefs, attitudes, and knowledge, if you can change those, then that influences behavioral intentions, like so people's intention to maybe change how they're doing something, and then ultimately, possibly, it might change their behavior. So that's really where we're focusing on this left side, where we can provide some knowledge and maybe we can influence some attitudes and some beliefs. So that's where we were working. Okay, next slide. Here we're presenting, this is the very small amount of quantitative data that we were able to gather during this brief implementation phase. So we did an introductory orientation webinar. There was about 23 people participated, and of those 35 were judges. And we asked a number of questions. Just the top level highlight here is that on a scale of 1 to 10, they rated their knowledge of elder mistreatment at about 6.3. It's a little better than half. Their average readiness to use the worksheet was only at 5. So even after being presented, there was a lot of skepticism, I would say. That was fair to put it that way. But that was before we were engaged in working with the court systems. Then during one of the trainings that we did, We did another survey, and that training, there were 32 individuals in it. That included all of those support professionals, the court-appointed attorneys, GALs, investigators, evaluators, and etc. And following that, we gave them a very similar survey, same sort of questions. And now they reported that their knowledge of elder mistreatment was about 7, so considerably better. And then their average readiness to use the worksheet was better, so it was at 6.5. So there was still skepticism remaining, but not as much as there had been initially. What I think is much more telling about this piece of the work really has to do with the qualitative data. And that came out of interviews and focus groups and really discussion around the use of the tool and the whole process of considering less restrictive alternatives in guardianship. So I would like to hand it off now to Kelly, who's going to walk us through that part. And I'm just going to say that because we had a very short timeline to go from sort of gathering data to today, these are the top level themes. It's not fully evaluated. It's really just the highlights of what we learned from our discussions with the court. Okay, Kelly.
Thank you, Bonnie. Next slide. So in jurisdiction A, in both jurisdictions, we wanted to understand what the value of the worksheet was from the judge's perspective. So in jurisdiction A, the judges told us that the worksheet captures the kinds of information that they need to make informed decisions. This jurisdiction had a good understanding of how conflicted families end up in guardianship, and they said that the worksheet helps them to be a bit more systematic in how they evaluate the person's needs and whether the proposed guardian is appropriate. They also said that the worksheet served as a reminder to look for things that either don't show up or might be missing from the case file. It wasn't that they filled out the worksheet per se, but they rather looked at it so that it signaled the types of details that should be in the case file. So in that sense, it functioned as a reference point for identifying what might be lacking. They also saw potential in the worksheet to help stakeholders like guardians ad litem, attorneys, examiners to submit more targeted and useful information. A few judges even suggested that tailoring the worksheet specifically for each of those various roles might be a good next step. And finally, judges in this jurisdiction appreciated that the worksheet reinforced their legal responsibilities. It helped keep them anchored in core mandates, like making sure less restrictive alternatives are seriously considered. So even if the worksheet isn't being completed, it still served as a shared frame of reference, not just as a checklist. Next slide. So we wanted to also understand what shaped the use of the worksheet. So in jurisdiction A, the judges described using the worksheet more as a guide or a cue rather than something that they filled out formally. They found it especially to be helpful in complex or contested cases, the kinds where there's family conflict, unclear motives, or perhaps questions about capacity. So in those situations, the worksheet helped them slow down and think more critically about their decisions. They did also acknowledge, though, that time constraints and heavy caseloads sometimes made it harder to use the worksheet in a routine way. So for straightforward and uncontested cases, it didn't really fit the pace of the courtroom, and it was often not sort of practical to reference it. Some judges, again, reinforced that the worksheet would be quite useful in complex cases or cases where there is, again, a family conflict or complicated family dynamics involved. And finally, the worksheet was seen as valuable for training and preparation, especially for new judges or judges who don't regularly handle guardianship cases. One judge even said that the worksheet reinforced their own training and that it helped keep critical issues in sort of front and center, even when the pace of the court was quite fast. So next slide, moving on to jurisdiction B. Again, we wanted to know what the value of the worksheet was by the judges and the guardians ad litem. So in jurisdiction B, as Bonnie mentioned, we had fewer participants, but we did learn that the worksheet was initially seen as potentially duplicative of already existing procedures and GAL reports. However, over the course of time, the judge in this jurisdiction came to see the worksheet as a really useful aid, not something to fill out formally during proceedings, but as sort of a prep tool or bench card to help them organize key considerations ahead of hearings. So less restrictive alternatives in this particular jurisdiction were typically considered before the hearings, with guardians ad litem and petitioners responsible for sort of surfacing those less restrictive options. But finally, they expressed strong support for using the worksheet in training, similarly to jurisdiction A, especially for new judges and attorneys. They thought this would be a helpful tool for judges and attorneys who are newer to guardianship practice. Next slide. So as I mentioned, in jurisdiction B, capacity determinations and considerations of less restrictive alternatives are largely handled pre-hearing by guardian ad litems and petitioners in accordance with this state's statutory process. They did view in this jurisdiction supportive decision-making as a potentially useful alternative in limited cases where the individual is cooperative and resources are available. Of course, those conditions aren't always met, but they did view supported decision-making as potentially useful alternative. Capacity determination itself in this jurisdiction was largely framed in binary terms, meaning capacity was either present or absent. So there was a little less focus here on retained abilities, which may constrain the range of less restrictive alternatives being considered here. Participants, though, did share with us that recent system level reforms in this jurisdiction have greatly improved post-appointment communication and service coordination, as Bonnie mentioned, with the aging network, which the court found quite valuable. But in terms of the initial determination, the court continues to rely heavily on the guardian ad litem reports as the primary source of information in order to make its determination. So those are the top line qualitative findings that we found in these two jurisdictions. And I think I will pass it back to Bonnie at this point.
Okay, very well. Thank you, Kelly. Next slide. Okay. Thank you. I understand we have 25 minutes left, so we'll make sure we cover the balance of the information and still leave some time for a bit of discussion here. So talking about the less restrictive alternatives, it was clear to us that there was more work to be done here. And so we dug in and did a little bit. Next slide. Okay, what we came to understand is that judicial officers, the judges themselves, are not directly trained in how do you think about what are less restrictive alternatives for this individual under these circumstances. That it doesn't really fit with what their role is. That they would be the one to figure out, well, this person needs Meals on Wheels and that person needs an adult day program. That just doesn't seem to fit with what a judge's role is. But it sure seems that the support professionals within the court or around the court do need to understand those and understand them well. And at times, they may not feel empowered to suggest what those less restrictive alternatives might be, even when they might identify them as potential resources. So they need to feel empowered that they can bring them forward and say, include those in their reports. The court structure and the statutory framework around whatever is operating in any jurisdiction may actually be part of who and how less restrictive alternatives should be considered. So, we were hoping to learn from this project, thinking of these two jurisdictions as sort of case studies, like when does it work? What kind of structures need to be in place? How does the court better move towards this? It's not going to be one thing. It's going to really depend on the structure of that jurisdiction and the statutory framework that they're working within. That's what it seems quite clear. Knowledge of local resources is critical. If you don't know what's available, you can't really make recommendations for what the service ought to be that will help this person. So it is very local. It's very much about what's available in your community, what's available, how do you get access to that, what's the referral process, and I think that's tough. The court isn't really that's not really their business. That sits over here. The court's business is creating the safety for the individual. There has to be some crosswalk between those two. Ro, would you be so kind to put the less restrictive alternative guide into the chat? So we developed this tool, and I'm going to say full out right now with full disclosure, we did not have the opportunity to use this in the jurisdictions we were working with. So it's kind of just, we developed it, it hasn't been tried, it hasn't been tested. It may be spectacular and work beautifully, but I'm sure it probably needs some refinement and it's through use that things I believe really become more effective. Next slide. So it's in the chat. Download it if it's helpful for you. Use it. Send us feedback. I would love to hear, oh my gosh, this is terrible. I don't like this part. That makes no sense or whatever. But we welcome feedback, and you'll have our email in just a little bit so you can do that easily. So this is a 3-page form, as you can see. This is just a screenshot of it up here. What we did is try to organize the information into categories that would help, think about where do we just even start here? So you have to start with what the client's need is. What is the unmet need? And then what is the resource that might solve that? So we looked at it as day-to-day functioning. When individuals are struggling with that, is that what led to the petition in the first place? Were there unsafe living conditions? Was there problems with financial management or fraud or elder abuse? Was there medical decision-making issues that brought this case forward? Or were there mental health disorders? Or is it lack of social support? Is this an unbefriended older adult in the community who doesn't have the support that they need in order to function well? And thus the petition was set up. So those are the sort of categories, how we organize that. And then we offered possible less restrictive alternatives that might work. They're not prescriptive, so it's not like if this is the problem, here's the solution, but like look here, look in this area of services. And then we provided some very brief examples. So it doesn't solve the problem, but I'm hoping, or we're hoping, that this gives the user a structure or a way to think about how do we get closer to using this really on every case. Is there a possibility that a less restrictive alternative could be implemented? And so next slide, please. In thinking about, I don't know, the many years of trying to identify interventions in elder abuse cases that actually work, and doing evaluations, myself doing evaluations for guardianship, and generally helping families of caregivers of people who have dementia understand like what's going to help this person function well. Things fail for a lot of reasons, and while this is not based on evidence, this is sort of my own this is what makes something effective. First, it has to be targeted. It has to meet the unmet need of the individual. There's a lot of resources. You can throw everything at this person, but if it's not the one they need, it's not going to solve the problem. So it has to meet that specific targeted need. What is it? So you have to understand the individual's need, where the risk is coming from, and then what's going to address that. So that's the first thing. Secondly, it has to be accessible, meaning that it has to exist in your community. You have to be able to get there. Maybe it's transportation. You have to be able to afford it if there's a cost involved. And the person has to be able to qualify if there's some restriction on who can access that service. And I believe it needs to be culturally aligned so that it feels like it's a good fit. But for any of those reasons, a resource could fail. So think about, is it accessible to this individual in the context of their life? And then the last one, and this is probably the one that causes resources to fail for individuals most frequently, is that it's not wanted. Does the client want to engage in this? How many times has there been an individual who needs an in-home caregiver? Somebody is brought in, but the third time that the caregiver is told to go away, no, I don't need help, because the client doesn't have insight into their own needs. That's a hard barrier to overcome. You can have the resource, but if the client is not accepting of it, then it may be not a viable alternative to guardianship. Also, there are times when family conflicts can really play a role here, where if the family is not aligned around the kind of care or the kinds of needs that this individual has, then you can bring a less restrictive alternative in. But if there's going to be ongoing conflict around that, it may be that it won't sustain over time, and that then guardianship is a needed remedy to cause that resource to actually work. I would encourage the court in those sorts of situations to look to narrow the scope of the guardianship so it meets that need and it doesn't expand to all areas of that individual's life. And I think that's what we're trying to get to, where it's really targeted to meet the need and not exceed it. Knowing that that kind of approach does introduce some risk, and it's how much risk can we tolerate? So with that less restrictive alternative guide, we encourage you to use it. Let us know what you think, and hopefully it can be made better over time. Next slide. Okay, so now I'm going to just talk about the worksheet in practice, sort of in a really global terms. What did we learn? Next slide. So generally, we found that judges liked it. They felt that it helped to guide and inform their decision making. And that almost universally, all the judges who had contact with the worksheet said that the professionals that support the court would benefit from using the worksheet as a way to focus their contribution to the assessment of whether the guardianship is needed in this case. They wanted everybody to be sort of aligned around, these are the factors I need to know about. If you can bring this information forward in your reports, it doesn't have to be on the worksheet, but the worksheet is really meant to make sure you're covering the right content so that it gets to the court. Then they said that it served as a consistent reminder of that statutory mandate to consider less restrictive alternatives. And the judges generally said that this is a useful process, that stimulating and sort of reminding them of that is useful. However, the court needs to identify resources and figure out how that intersect with what those resources in the community are, what we refer to as the aging services network. There needs to be a better alignment around that. And that the resources need to be targeted, accessible, and acceptable to the respondent. Okay. I think that's it. I will move to the next slide. And I think that's our questions and comments. Okay. Do you want to take this down, the slide deck down, Andrea, and then we will put that back up when we're done for the QR code. We have 15 minutes. Oh my gosh, timing worked out well. For some Q&A, if people want to, I'm not sure how to do that. Ro, do you want to help, like, sort of guide us through questions that are that were put in the Q&A, and we can do our best to answer those?
Sure.
Okay,
I'll
great.
go ahead and get started. There's a question from Nancy Coleman. Do you think that where there's a guardian ad litem, that there is a conflict between the person and the role in reporting to the court?
Um, I imagine that there are times that there may be a conflict, but I don't know that it's inherently built in. The role of the guardian ad litem is often really important. And it's a bit different in different jurisdictions, as we were describing. But I don't know that there's an inherent conflict. I'm going to ask Lori, do you want to add anything to that about how that role is?
Yeah, I would agree, Bonnie. I'm not sure that there's an inherent conflict, but again, each situation is different and has to be evaluated on its own merits, the facts and circumstances presented.
The next question we have from Carrie Flora. What if those agencies don't know or understand what less restrictive alternatives to guardianship are? Is there a plan to ensure they do?
The agencies that I'm not sure, and you can unmute yourself if which agencies are we referring to?
This was when we were talking about the aging network.
Well, they may not know that they are sort of a mechanism for someone to remain safe without the need of guardianship. And so I think that it would be wise to educate them to those kinds of roles, that how the service that they provide to an individual in the community can lead to greater safety, so that that protection is, the need for that is obviated. I suppose there's a role for education in that. Lori, Kelly, what do you think?
I agree. I think education is really important. Education for everyone in the ecosystem.
Looks like we have one other question. If anybody else has any question, please do type it in. This is from Erica Folkels. Does the Keck School of Medicine provide ongoing professional training or webinars like the one presented today?
Well, I'm going to say yes, we do. With some constraints in that, in the present environment that we're working in, we need to have funding in order to do this kind of work, and that at times is tenuous. So, but we are very much focused on gathering information that's reliable and based on evidence as much as possible, and aggregate evidence, and then bring that forward to the community, whatever that group might be, whether it's a professional community or it's a lay community, or bringing that forward in ways that it's accessible to people. So yeah.
And I would add to that the National Center on Elder Abuse is housed at the Keck School of Medicine. And we will be having a webinar coming up on June 11th regarding financial exploitation. And Dr. Olson will be one of our speakers, but it should be a really interesting and engaging conversation. And I will look for that information, put in the chat.
We do have a hand up from Karen Daniel. Just 1 second. There's one more question in the chat, and then we'll go to you, Karen. This question is from a Jenny, Ryman Schneider. I hope I got that right. When will there actually be review and enforcement of the requirement for least restrictive environment? Who is responsible for this?
Well, ultimately, the judge is, the judge who's writing the orders for guardianship. They're required to, diligently look for, were there less restrictive alternatives that would have solved this problem? My experience in working with the judges, they take that seriously. Some perhaps more than others, but I think that generally speaking, judges do know that there is a statutory obligation and that there's people's lives on the other side of this. They want to do the right thing. I think getting the right information to the court is critical. So having those professionals that surround the court really bring and feel empowered to say, hey, wait, maybe this could work. Maybe we could try this for 6 months and bring the case back and see what happens. That's what I would advocate for. And that maybe trying to write orders that are more targeted to the actual issue and not have it be quite so broad would better serve at times. I also believe strongly that there are times when a less restrictive alternative is just not viable, and that guardianship, plenary guardianship, is the best solution. I think we're all kind of rowing in the same direction. We're all trying to get to a better place with this. But it's a complicated process and it's hard. So when will that be? How will that occur? I don't know, but we're trying.
Thanks, Bonnie. Karen Daniel, if you would like to ask your question, I'm gonna take you off mute. Okay, go ahead.
Karen, do you want to speak?
All right, Karen, come back to us if you are able to before we end the webinar.
I wanted to mention, I see in the Q&A that Karen, I will mispronounce your name, Tofor, has a training program for assessing decisional capacity, and really important because it is those assessments and the reports that generate out of those assessments that the court relies heavily upon. And if there are opportunities as a result of those assessments to offer to the court the opportunity to write more restricted orders that are not quite so broad, or alternatives to the guardianship in the first place, that I think that you're doing a great service to the court by doing that. When I write those reports, and I know it's probably the last summary paragraphs that get read, I am really explicit with the judge about these are the circumstances that this person will function best. If these are put in place, this person might not need, their level of capacity will improve. I obviously am not offering the ultimate recommendation as to whether the person needs to be under guardianship or not, but shy of that, I try real hard to put that into my recommendations. So good luck. I hope that can happen.
From Nancy Coleman, it looks like you would like to ask a clarifying question regarding the guardian ad litem. Would you like to answer it live or come off mute? Hi, Nancy.
Okay, so I want to go back to this question. If the guardian ad litem is appointed by the court to represent the person who might be under a guardianship, then how can they also be the court investigator? I see those as two very different roles. And I think that they need to be clarified prior to the person thinking that this is their advocate and the spokesperson for that person. Again, I know it's a difference between being the attorney for the person, but it also could be that it is the advocate for the person.
Yeah, I understand your question, Nancy, and it unfortunately in that jurisdiction it was required by their legislature. It's in their statute that every case is provided, every respondent is provided a guardian ad litem. I don't know how it came to pass that role also became the investigator, but it's the structure that exists today. So right, wrong, or indifferent, it is what is occurring currently in that jurisdiction.
In that jurisdiction.
At least that was our understanding. Yeah, I'm not saying that universally that's what happens. No, just that's what it appeared to us based on our discussions with them.
Thank you, because I think it's a conflict. I mean, but again, I'm a biased observer and looking at lots of different states.
Understood. Thank you. Anyone else? Any other last questions or comments? Is there anything else in the Q&A row that we should address?
I'm not seeing specific questions, but we do have a comment from Hillary Dolan. Most important to bringing the voice of the person proposed for guardianship into court most often depends at the time upon the person having a lawyer who advocates for them. That's not usually the case for guardians ad litem.
Understood. Yes, I agree, Hillary, and thank you for being here. Yeah, first off, the respondent should be in the room for the hearing, if not remotely. But having them not present feels like the only time that should happen is really if it's a hardship, or it would be physically, medically complicated for that to occur. But yes, and in both phases of this project, we heard repeatedly from judges that they valued interacting directly with the client, the respondent, in the hearings. And so I think that's an area where maybe there's ways to push on that so that that client's voice gets into the process, because it matters. It's their life that is in a question, not their life, but their the circumstances of their life. So yeah. All right, I think we can end there.
If we could share the QR code, Andrea.
So there's a brief survey attached to this QR code that we would be grateful. I mean, we're asking this with gratitude, and it really matters to hear back from you some comments about your experience of listening to this presentation today. And again, we will make our emails available, and so particularly regarding the less restrictive alternative guide, if you have input to that, we would be delighted to hear from you. We may not be able to respond personally to every single one. I don't know what we're going to get back, but we will integrate comments and feedback, and our goal is to make a better process for our probate courts so that they can do the job they've been asked to do. Okay, thank you all. Appreciate it.